Power is not always loud. Sometimes it moves quietly, through money, influence, and private financial channels. The framers of the United States Constitution feared this kind of quiet power more than open political rivalry. They had witnessed how foreign governments manipulated leaders through financial entanglements. That is why they built constitutional guardrails designed to prevent any American president from becoming financially dependent on foreign interests. The question today is whether those guardrails remain strong enough in a modern world of digital finance and global capital flows. During the first Trump administration, critics argued that foreign officials could gain access or favor simply by spending money at properties connected to the president. The concern was visible and transactional, almost retail-level politics. But what we are examining now is more complex and potentially far more consequential. This is no longer about hotel bookings or event hosting. It is about cryptocurrency markets, sovereign wealth funds, artificial intelligence infrastructure, and presidential authority intersecting in ways that are harder to trace. At the center of this story is Changpeng Zhao, widely known as CZ, the founder of Binance, once the largest cryptocurrency exchange in the world. Binance experienced explosive global growth, but that growth brought regulatory scrutiny. U.S. agencies including the U.S. Securities and Exchange Commission and the Commodity Futures Trading Commission accused the company of violating securities laws and anti-money laundering requirements. In 2023, Binance reached a multi-billion-dollar settlement with the United States Department of Justice. Zhao stepped down as CEO and served a short prison sentence. For many executives, that would have ended the story, but here, it appeared to be a turning point. The second key figure is Tahnoon bin Zayed Al Nahyan, a powerful royal in the United Arab Emirates. He oversees vast sovereign wealth assets and chairs G42, a major artificial intelligence firm. AI development depends heavily on advanced semiconductor chips, particularly GPUs produced by NVIDIA. The export of these chips is highly sensitive because US policymakers worry about advanced technology being diverted to strategic competitors. In this arena, commerce and national security are deeply intertwined, and export controls often become tools of geopolitical negotiation. A third layer involves a presidential family entering the cryptocurrency market shortly before a national election. A new crypto venture was launched with a structure that reportedly allowed significant profits to flow to family stakeholders. After the election, foreign sovereign investment capital reportedly entered the venture, and a US dollar-pegged stablecoin was introduced. Stablecoins generate revenue through interest earned on reserves, often held in US Treasury securities. As reserves grow, passive income grows. The credibility and market value of the venture expanded rapidly. Following these financial developments, significant government actions occurred. Export restrictions on advanced AI chips were eased. A presidential pardon was granted to the crypto executive. Federal enforcement priorities related to cryptocurrency were reduced. From a legal ethics standpoint, timing is not proof of wrongdoing, but it is never irrelevant. When financial flows and official decisions overlap, constitutional scrutiny becomes unavoidable. The Constitution contains two critical provisions, the Foreign Emoluments Clause and the Domestic Emoluments Clause. Their purpose is straightforward: a president may not receive benefits from foreign governments without congressional consent. Historically, presidents have taken steps to avoid even the appearance of conflicts of interest. Jimmy Carter placed his business interests into a blind trust. Barack Obama donated the monetary award from his Nobel Peace Prize. The framers understood that public trust depends not only on legality, but on perception. The enforcement problem, however, is substantial. To prove bribery under federal law, prosecutors must demonstrate a clear quid pro quo, a direct exchange of money for an official act. Recent decisions by the Supreme Court of the United States have narrowed the legal definition of what qualifies as an official act. Presidential immunity doctrines further complicate efforts to use certain executive decisions as criminal evidence. As a result, even when money flows and policy shifts follow, establishing a prosecutable link can be extraordinarily difficult. The larger question is not partisan, it is structural. In an era of digital assets and sovereign capital, are constitutional guardrails equipped to prevent financial entanglements from influencing presidential power. In constitutional law, structure is everything.